The amendment, if your lordship sees, which is now there,
See, this amendment will apply only when internal is granted without furnishing copy and
furnishing
without hearing.
without it.
So therefore, if there is a notice issued, or in some high court's practices to serve state in advance,
Yes,
this will not apply at all.
this will not.
If copy is given and notice is served,
Served.
then this will not apply.
Yes.
Hardly significant.
We can limited cases.
So we can.
We don't need to go into it.
Judge, no name is not.
Going to 226(3), Lord, in this matter. It operates in a different way on
And
different.
in a very limited
conditions.
cases, it will apply.
Yes.
Because once A and B is complied with, then there is no question of an automatic
In high
vacation.
courts, in both high courts,
I'll tell you, Lord, I would submit before your lordships why it's not necessary. Asia resurfacing essentially concentrates on stay of trials. Stay of trials would arise either in 482 or other jurisdictions.
227.
227, not in 226.
26.
But 226, my lord, we would be taking support, my lord, to substantiate other submissions. Just to say, my lord, that first, it's a part of the constitution. Here, it's a judicial continuing mandamus. Second, there is at least a requirement of an aggrieved party applying for vacating the stay. Here,
Automatic, without.
person who is not vigilant enough and sits for 6 months, he is put to premium by getting the stay against him vacated. He has to do nothing except being negligent, to put it, my lord, a little harshly. So that's the position. So 226 may perhaps not, my lord, require your lordship's attention in this matter.
Yeah, they were wrong.
not the copies are served in advance on the state councils,
Absolutely.
except in private disputes. Otherwise, their state councils are always served. And they have an opportunity of being heard. It's other matter that the state government advocates may not be having instructions, etc. So they get time alerts.
Thing in particular that you would like to add?
Only 2 or 3 things.
No, I have not stated.
All right, we will hear you. All right.
Right.
So,
I'll not take more.
how would you like to formulate the submission then, Mr. Dwivedi?
But I have 7 points.
7 points, all right.
Yes.
Just tell us. 1 second.
The judgments I have mentioned in my written submission, but I will not be
Correct.
taking your lordship through it. The propositions are all well settled and well known to your lordships. First is that this direction amounts to judicial.
Which is that volume, Mr. Dwivedi, your written submissions?
Separate volume.
So,
Separate folder. There's a
Separate volume.
It's a separate volume. High Court bar.
yes.
They were allowed to intervene in the High Court. My lords. And
Correct.
the first submission is that this direction of automatic vacation is laying down of a general norm,
Direction for
automatic vacation of interim order, lays down a general norm, and therefore it is in the nature of judicial legislation. And this court, Lord, does not engage in judicial legislation.
yes.
In the same-sex matter, my lord, the lordships have elaborated. I don't need to, my lords. The second submission, my lord, that Article 226 is a part of the basic structure of the Constitution. And it can neither be shut out or nor whittled down either by constitutional amendment or by legislation and ought not to be shut out or whittled down in exercise of powers under Article 141 and 142. This is also because, my lord, the High Court,
This is the third point or the second?
third point,
Third point.
is part of the same point, my lord.
All right.
This is because the High Court enjoys a high constitutional status and it's not subordinate, my lord, to the Supreme Court. This also, my lord, has been held in several judgments. So merely because, my lord, there is a problem arising, that doesn't mean that the power of the High Court should be curtailed, and there should be any kind of a general direction that even if you have not applied, even if you have not vacated, we are saying it will stand vacated. And even we will not apply our mind, it will get automatically vacated.
Yes.
So the third point, therefore, is that the automatic vacation is neither hinged on application of mind by the High Court nor by the Supreme Court. And application of mind is the essence of judicial decision making. Without which the decision would be arbitrary. So even though, Lord, Article 14, etc., fundamental rights are not available to test the judicial dictums, yet your lordships have consistently observed that arbitrariness in decision making is to be avoided. The fourth point is the arbitrariness and the discriminatory character of this direction arises from the fact that it lumps together all sorts of cases, civil, criminal, tax, irrespective of facticity
Irrespective.
of the cases, nature of jurisdiction, and determination of fault. For if I am delaying, Lord, I having obtained interim order twice, thrice, four, I can understand High Court vacates it. Not by an automatic direction, but High Court vacates it because then the next is, Lord, a speedy trial includes early termination of vexatious trial also. And this direction does not reasonably balance the two aspects. So both section 482 and 226 are available for quashing of FIRs and charge sheets and so even charges in an appropriate case. So one can understand that the court may be directed to be slow, lords, or to give reasons or to hear. So these are 3-4 directions which can be and should be rather introduced so that straight away, or maybe it can also be said that in heinous crimes and serious financial irregularities cases or economic offences, if an interim order is to be given, it should be initially for a short period, as the Lordship says, till the next date of listing, so that an opportunity, effective opportunity is there. Government counsel may not be having instructions, so and that will not prevent the High Court from granting appropriate relief. The relief can vary. Sometimes it can be arrest, sometimes it can be staying the whole proceedings. It all depends upon the circumstances. Because we have also seen that there are cases where matters have been settled up to the Supreme Court and people still will not fight it out by filing FIRs, then they resort to criminal proceedings. Some civil nature disputes, they're all carried only to harass. So if in such cases a direction is given till further orders, all that power is there under 226. So there has to be a proper balancing and some minimal directions alone should be given so that there is a guidance to the court, High Court. And lastly, this ignores two precedents. Though in the context of trial, not interim order, that is HON'BLE's case and P. Ramchandra Rao. At page 4 of my written submission, in paragraph 4, I have given the paragraphs at the footnote. I will stress only para 82, 83, 86, 93 and 94 of Antule's case, that is 1992, 1 SCC 225,
In your submissions, where is it, you said?
paragraph 4, I very briefly stated. Two constitution benches in A.R. Antule's case and P. Ramchandra Rao have, while dealing with the fundamental right to speedy trial under Article 21, held that it is not permissible for this court to fix time limits for completion of trials. The reason assigned is that delay in trial could happen for a variety of reasons. May I read these two judgments or I can leave?
No, it's very well settled.
P. Ramchandra Rao, my lords, may be seen only because
Okay.
after Antule's case came three judgments of this court, where this court identically as in Asia resurfacing proceeded to say that if trial is not completed in 360 days, then trial will terminate. So the matter went back to P. Ramchandra Rao, and they said that this is judicial legislation.
It's in your convenience compilation?
Yes, yes, it is there. Correct.
1399.
PDF 1399. Laws will find the reference, the issue which was involved. And towards the middle, you'll also find Rajdev Sharma 1, 2. All these cases, they said, if not concluded, it will terminate. Then in paragraph 19, Antule's case is noted. And Placitum F, if a lordship comes to Placitum F, there are other factors contributing to the delay at the trial. And so all these various reasons for delays are noted, and the court says it's all relative. First is non-availability of the counsel, non-availability of accused, interlocutory proceedings, other systemic delays. In addition, court noted that in certain cases, there may be a large number of witnesses. In some offences, by their very nature, the evidence may be lengthy. In Kartar Singh, another constitution bench opined that delay is dependent on the circumstances of each case because reasons for delay will vary, such as one, delay in investigation on account of the widespread ramifications of the crime and is designed network either nationally or internationally, the deliberate absence of witness or witnesses, crowded dockets on the file of the court, etc. So all that is said, and then paragraph 20. Several cases coming to our notice while hearing appeals, petitions, and miscellaneous petitions, such as for bail and quashing of proceedings, reveal, apart from inadequate judge strength, other factors contributing to the delay at trial. Generally speaking, these are absence of or delay in upon. Again, those reasons are mentioned. And then 21, the question is posed, is it at all necessary to have limitation, bars terminating trials and proceedings? Is there no effective mechanism available for achieving the same end? The Criminal Procedure Code as it stands incorporates a few provisions to which resort can be had for protecting the interest of accused and saving him from unreasonable prolixity or laxity at the trial amounting to oppression. Section 309 is then referred to. Your Lordships can then leave the rest. Please come to 22. Legislation is that source of law which consists in the declaration of legal rules. Again, this definition of, and then the court holds.
Subject of bail.
Last line at page 1421. Bars of limitation judicially engrafted are no doubt meant to provide a solution to the aforementioned problems, but a solution of this nature gives rise to greater problems like scuttling. A trial without adjudication stultifying access to justice and giving easy exit from the solution. from the portals of justice. Such general remedial measures cannot be said to be apt solutions. For two reasons, we hold that such bars of limitations are uncalled for, impermissible. First, because it tantamounts to impermissible legislation, an activity beyond the power of the Constitution conferred on the judiciary. And secondly, because such bars of limitation fly in the face of law laid down by the Constitution bench in A.R. HON'BLE's case, therefore run counter to the doctrine of precedence. There's a quote from William Wade's judicial activism and so on. I can leave it. And then 27, prescribing periods of limitation at the end of which the trial court would be obliged to terminate the proceedings and necessarily grant, acquit, or discharge the accused, and further, making such directions applicable to all the cases in the present and for the future amounts to legislation which, in our opinion, cannot be done by judicial directives and within the arena of judicial lawmaking power available to the constitutional courts, howsoever liberally we may interpret Article 32, 21, 141, 142 of the Constitution. The dividing line is but perceptible. Courts can declare the law, they can interpret the law, they can remove obvious lacuna and fill the gaps, but they cannot entrench upon the field of legislation properly meant for the legislature. Binding directions can be issued. For enforcing the law, and appropriate directions may issue, including laying down of time limits or chalking out a calendar for proceeding to redeem the injustice done or for taking care of rights violated in a case, in a given case, or set of cases depending on facts brought to the notice of the court. This is permissible for the judiciary to do so, but it may not, like the legislature, enact a provision akin to or on the lines of Chapter 36 of the Code of Criminal Procedure 1973. The other reason why the bars of limitation enacted in Common Cause 2, Rajdev Sharma 1, Rajdev Sharma 2 cannot be sustained is that these decisions, though 2 or 3 judge decisions, run counter to the extent to the dictum of the Constitution bench in HON'BLE's case. Therefore, cannot be said to be good law to the extent they are in breach of the doctrine of precedents. The well-settled principle of precedents which are crystallized into a rule of law. Now that's known, Mullahs. And then they affirmed the directions in para 29. So Mullah, it's somewhat similar. These kind of directions are actually judicial legislations, something which even Article 368 will not include within its fold.
Yes.
And there is, apart from these submissions, what happens is in the course of it, that by issuing these directions, we are not enabling the high courts to conduct themselves in appropriately in dealing with the case, but rather disabling them and downgrading the status over the course of years. And in one such matter, in this court itself, when Chief Justice Keher was, I think Vijay was there, was retiring, there was some letter from the law minister.
Right.
Yes.
And regarding selections of judicial officers in the high courts and the rules to be made. And then the committee of judges of this court that accepted that proposition favorably, and immediately a suo motu petition was listed. And Justice Goel was chairman of the committee also, and he sat in the bench also immediately. And this was just a few days before the Chief Justice was retiring. So the matter went on for 2 days, and there were so many judgments. I said, how can you intervene? How can you take over the power of the High Court? It was a very serious matter. And ultimately, it's the second case where the bench was disbanded after that Keshwanand.
Yes.
So just after the lunch, then he inquired, do you really think this requires serious consideration and we must... I said, don't be hasty in this matter. For so many years, this has been continuing. Even if you want to change, please consider it carefully and then come out. So there is some kind of a tendency sometimes that we try to limit the powers of the high courts. What we really need is not that the high courts should be getting on with their functions and discharging their duties and functions and powers under the constitution more effectively. I don't need to elaborate. Lord, your lordships are all more aware than me, Lord, what is happening in various high courts. So, but then these are not the solutions at all. Let's not curb the high court. The time is to rebuild the high court and put them, Lord, on a strong footing so that the high courts function like high court. Because they are ultimately, Lord, there is some kind of course, there's no such federalism in the judicial field as we have, Lord, in the other. Where judiciary is structured differently, Lord. It has some various elements of unitary operations. But at the same time, Lord, the High Court is the ultimate court in the state. 80 or 90% of the litigants are not able to come to the Supreme Court. Now, therefore, we don't need to not keep on. Different methods have to be found. Able judges, less strikes, more lawyers, because we don't have hearing. I wonder, Lord, what will happen after some time if the high courts are not having final hearing. We used to sit. When I was in law first year, first day, I used to come and I heard the whole of Keshwanand Bharti, Lord, just Palki, and I used to sit with a register behind. Lord. So by hearing, even in high courts, we have learned from the seniors how they are arguing, how they are responding. But today, what we are finding is less of arguments and interim orders. People don't understand what happened in one case, what happened, why not in the other case, in this case. So it's ultimately that part somehow in some way has to be tackled. Unless the high courts are put on rails as constitutionally imagined by the framers of the constitution, there will be dark days for this court, Lord. Ultimately, high courts are the feeding source for this court. Main feeding source. So let's put High Court, Lord, on the rails, strengthen them. That's the only solution. Not this kind of tickling, Lord, that after somebody suggests, Lord, that after 3 adjournments it should be automatically vacated. I mean, so we are distrusting the High Court judges. All these propositions show that we don't have trust on the High Court judges. Somehow we feel something wrong is happening there. Maybe.
There was a similar provision actually in the Central Excise Act, or Mrs. Harris, the tax, which was then dealt with by several high courts, that there can't be an automatic vacation of stay merely because the court is not able to apply its mind.
At page 5, you'll also
that
find
was read down, my lord, by this court.
At page 5, Pepsi.
That's right, it's Pepsi. That's it. 2021.
And surprising, I'm surprised with Justice Nariman, my lord, went down that line and accepted the proposition. He believes in basic structure. But and in this second case, in paragraph 6 of my written submission, or Pepsi mein hai, no. In Pepsi, Justice Nariman himself said that, diluted it, struck down portions of it, and said that only if there is fault of the applicant, then it will stand automatically vacated, not otherwise. So he adopted the fault principle.
So there are two problems. One, the automatic vacation of stay prejudices a litigant, irrespective of the conduct of that litigant, because there are circumstances of which the litigant has no control. Yes. And yet, there are many times systemic flaws, yes, as a result of which, irrespective of what the litigant has in terms of infrastructure available to him or her, stays are vacated by this logic.
Yes.
And second, the vacating of an order of stay is also a judicial act. The vacating of an order of stay is not an administrative act. So by directing that the stay will stand vacated without application of mind, a judicial order is in force, as a result of which, notwithstanding the fact that the earlier bench had applied its mind, given reasons, yes, for the interim order, right, applied its, there's judicial application of mind to what the prima facie merits of the case were. Subsequently, the stay is vacated without any application of mind.
Nobody, not even this.
Normally, when we vacate an order of stay, you give reasons for vacating an order of stay. Maybe that the litigant had abused his, abused that process, or he had concealed facts from the court.
And every day we are having appeals here against interim bails granted, and interim orders also people are coming.
Actually, it amounts to withdrawing High Court's jurisdiction.
Absolutely.
Judiciary taken away. 226, 482,
It is actually
227.
great distrust in the High Court, which is reflect. That's why I was compelled to make those submissions with great deference. It's actually indicating distrust in the High Court judges. So why are we having the High Court at all?
In fact, that's why many of us don't lay down outer time limits for the High Courts to decide cases. In fact,
Lordship say guardedly endeavor to do so and like that. And even when it is said in clear terms, yet Lordship considers it to be directory. It's not that a judgment will be set aside merely because it has transgressed 365 days and comes after 367 days. That's why I was compelled. These solutions, let's not find solutions. Let the High Court have that full wide jurisdiction which your Lordships have said under 226. Ultimately, even this court will get clogged. If there are 4 benches extending orders every time, then there will be so many more SLPs coming here, then your Lordships' precious time will be involved in dealing with them.
So the High Court is ignoring this.
Power to grant interim order is, that's the last one, the power to grant interim order is inherent in Article 226, 227 and 482. It doesn't stand outside it. That is only to preserve
The stay order should also be available.
and protect. That's all of Jagan.
Just continue to the number.
285, the High Court has dealt with this aspect of interim orders. The Lordship may just note 285 to 287.
PDF.
They have noted. PDF 311.
in the same compilation or convenience compilation
The paper.
Main paper.
or the paper book.
Main paper.
502.
And I must commend, my lord, the judgment is very exhaustive, though it's a little bit lengthy, my lord, but it deals with a High Court dealing with a Supreme Court judgment, my lord, has to be careful with all due care and a very well written judgment, my lord.
Is referring to allow an High Court for
Yeah.
the Supreme Court.
तो ठीक है, क्या करूँ उसके? Thirteen of my written note was at page 7 in Fazalullah Khan versus Akbar contractor. The question was not whether this direction will apply to interim orders granted by Supreme Court itself. He said no, it will not apply to 32. So 32, 226, ultimately both are very important constitutional powers. That observation is per incurium because there was no such issue involved
It
in
was
that.
not an issue before the bench at
Yeah.
all.
So following what your Lordship said in Article 370 case about Premnath Kaur's judgment. Grateful.
I'll not take more than 5-7 minutes, Lord.
Yes.
I filed an intervention application.
If you don't mind, can I complete?
Can-
Can I complete? You might take
Can we
a-
complete this side? I'll just take 5
There's
minutes.
no side.
No, there is no side.
Side, really.
There is no side.
So we'll
Yes.
let the solicitor complete, then we'll hear you for 5 minutes.
Well, just, my lord, I'll summarize, my lord. My lord, I have, for your lordship's convenience, my lord, I have made certain bullet points, which are, my lord, mailed today in the morning. my lords. And I'm not going to read any of them, my lord. First, at the outset, I may say, my lord, my first respectful submission is that by a judicial mandamus or a continuing mandamus, the judicial discretion of the High Court cannot be curtailed.
Today morning it has been said.
Your lot, I'm sorry. Lord, your lordships, my lord, would be, High Court would be dealing with either in 227, 482. But I'm sorry, my lord, today it is reversed. Your lordships have physical copy and I am, my lord, having. But I am at fault, my lord. Your lordships, I'll invite your lordship's attention only to few points, my lord. Lord, suppose in a 227 or a 482 jurisdiction, an accused approaches the court saying that there is no valid sanction. High Court is satisfied. And High Court says that till the sanction is granted, trial not to proceed. Lord, the 6 months period, my lord, the judgment takes away the discretion of the High Court to say that the stay would endure till a particular date which is beyond the reach of the applicant. Lord, second, Lord, Indore Development Authority, my lord, a recent judgment, my lord, has recognized the principle of actus curiae neminem gravabit. Your lordships are aware, my lord, of that. Act of the court can prejudice no one.
Yes.
But a somewhat similar situation was there under the new Land Acquisition Act. That period of 5 years from the stay granted by the High Court was to be excluded. And court said that it's not in the litigant's hand when the stay would be vacated, when it would be granted, modified, etc. My lord. So, my lord, that is my second point. Lord, coming to page 2 of my note, Lord, there is a Constitution bench judgment, my lord, which Asian Resurfacing misses to note. Lord, that is Raza Buland Sugar Company versus Municipal Board of Rampur. Lord, the proposition is simple in that judgment, that nothing can be done behind the back of or in absence of the litigant.
Yes.
Lord, on 188th day, Lord, the 6 months period, matter may be on board, matter may not be on board, he would not be aware of, and by operation of the direction, my lord, the stay would get vacated. My lord, that is contrary to this Constitution bench judgment. But at page 2, my lord, I have cited one paragraph of Sharifuddin versus Abdul Ghani loan. If your lordships can allow me to place it, my lord, para 69. So that is, my lord, in my respectful submission, fully, my lord, applicable. Therefore, it is clear that if the condition imposed by the provision of law, this was statutory law, this is continuing mandamus, to do a certain thing within a time frame is upon an institution, and the consequences of that institution not complying with the condition is to fall upon someone else who have no control over the institution, which is to perform the duty, then the provision of law cannot be construed as mandatory, but only directed. Here, the litigant has no control, and even court has no control over his list. My lord. The lists are beyond human potential. My lord. Next judgment is, my lord, Pepsi Food. My lord, there, section 254.
Yes.
There was an amendment in the Income Tax Act, section 254, within bracket 2 capital A was inserted. That a stay granted by the tribunal would get automatically vacated after 1 year. And High Court, my lord, the Dishonorable Court, my lord, said this, and this, my lord, I would respectfully place for your lordship's consideration. Such provision treats unequals equally.
Yes.
The person who has an interim order inuring in his favor, Lord, has once persuaded the competent court to grant it. The respondent has done nothing to get that vacated. So unequals are being treated as equals, my lord. And therefore also, my lord, this needs to, my lord, this is not a correct law. Then, my lord, next point is, whenever any court, my lord, passes an order, it passes broadly, strong prima facie case, balance of convenience and irreparable injuries. After 6 months, whether those conditions, these three conditions change or not, the judgment says it stays vacant without any application of judicial mind. Because after 6 months, the case will not become weak. It would remain strong unless heard. Balance of convenience also would not tilt merely because 6 months have passed. And injury also, my lord.
Yes.
Next point is, my lord, whenever, my lord, the judgment which Mr. Dwivedi relied upon, I also respectfully rely upon, but I'm not reading that judgment.
Yes.
Whenever a time frame is to be stipulated, it is always for the competent legislature to do.
But even those have been held to be, by and large, directory.
Directly. For example,
In the IBC, Insolvency and Bankruptcy Code,
IBC, or Arbitration Act.
the Consumer Protection Act.
Consumer, that after particular days, your right to file appeal goes. Because of the overall scheme of the act, the intent of the legislation, etc., etc. Because there is one focused area which the court is examining. This is not too wide an area, my lord. It can be a civil suit, it can be a criminal trial, it can be criminal revision, it can be 482, it can be civil revision under 115, it can be superintendent's jurisdiction under Article 227. But nothing is considered, and, my lord, a judicial mandamus is issued.
Generally speaking, directions for the completion of a trial proceeding by the legislature within a certain stipulated period is held to be directory. But since an appeal is a creature of a statute, directions for the legislative prescriptions for filing of appeals on limitation have been held to be mandatory.
Mandatory.
Like in Section 34(3) of the Arbitration Act.
Arbitration Act, my lord.
Or Section 61 of the Insolvency and Bankruptcy Code.
The curtain falls. You know,
can condone a delay up to 15 days, beyond 30 days, but no further.
Because time is the essence of that particular legislation. So time fixation, first of all, has to be by the competent legislature, and for the purpose of the object which that particular act seeks to achieve. It is always object specific. Then, my lord, your lordships are aware, my lord, Order 8, Rule 1 required that unless you file your written statement,
yes,
the court can extend only for 30 days. So that came to be challenged. I will read only 4 lines when, my lord, this honorable court dealt with, my lord, the challenge. So that your lordships would find at page 4. But the citation is Kailash versus Nanku, 2005, 4 SCC 480. Para 27, only last 3 lines. That is relevant, my lord, for the entire discussion, but I don't wish to, my lord, take time on that, my lord. But last 3 lines are crucial. The object is to expedite the hearing and not to scuttle the same. The process of justice may be speeded up and hurried, but the fairness, which is a basic element of justice, cannot be permitted to be buried.
Mr. Dwivedi was the amicus, no? I was agreeing.
So, my lord, any judicial discretion, my lord, should be left, my lord, to the concerned court, my lord, namely the High Court, and in some cases, my lord, District Court. But generally, the question of stay of trial does not arise in case of, my lord, proceedings before the District Court, except in case of a criminal division or some civil division. Generally, it is High Court.
Yes.
So, my lord, while the problem, my lord, is there, trials are stayed and it has its own ramifications, but this is not the solution. These are my respectful.
Thank you, Mr. Solicitor. Yes, Mr. Ansaria.
I appear in the IA number, my lord, 258440 of 2023 on behalf of Guwahati High Court Bar Association. And we are supporting, Lord, both Mr. Dwivedi and the learned solicitor, my lord. Just to add one or two aspects. Lord, wherever limitation is provided, it is upon the litigant, my lord. Lordships have, courts have put a fetter on the litigants. Section 34 Arbitration Act, appeal, and not upon the courts, my lord. If your lordship see the sweep of the directions in Asian resurfacing, my lord, in the compilation page 29, if I can read that, not 5 lines from that judgment. If your lordship go to that convenience compilation of Mr. Dwivedi, my lord, the judgment started page 3 of the compilation at page 29, just before paragraph 38. Lordship would say this sweep.
What page will that be?
In page 29, my lord, just starting in all pending matters before the high courts, my lords have got it.
Yes.
In all pending matters before the high courts or other courts, which will include special courts, etc., relating to the PC Act and all other civil or criminal cases, where stay of proceedings in a pending trial is operating, stay will automatically lapse after 6 months from today. The judgment is not delivered, unless extended by speaking order on the above parameters. Now, next line is also important. Same course may also be adopted by civil and criminal appellate revisional courts under the jurisdiction of the high courts. The trial courts may, on expiry of the period, resume the proceedings without waiting for further intimations. But sweep of the directions, it never been.
It also.
My lord, lots would see, I'm so sorry. Lots would see the consequence on a diligent litigant, my lord. He convinces the court, passes an interim order, thereafter listed after 1 month. It does not reach, or the respondent seeks an adjournment. The court is not able to take it up despite being on the board. I wait for the entire day, my lord. It doesn't reach. It happens, my lord, in so many courts, my lord. All of your lordship knows someone, my lord. So, my lord, as London attorney has rightly said, my lord, it is upon the institution, my lord, whether it is able to decide it or within that 6 months time limit or not.
Anything else?
And my lord, only one thing, my lord. Wherever the courts find, my lord, that preemptory order is upon again the judicial discretion, my lord. Sometimes your lordships and courts pass, it will operate for a period of 6 months or, my lord, 4 weeks. So, my lord, that qualification is given, my lord, in the order itself, that this stay will operate for a period of 4 weeks and it expires automatically. That judicial discretion is available to the court, my lord, which this court, my lord, in SS surfacing so, my lord, that it automatically vacates. Wherever the court wants it, it should automatically vacate. That is stipulated in the order itself, sometimes by your lordships, my lord, while exercising that discretion of the court, my lord. So it cannot, my lord, automatically vacate by virtue of this.
We do it so often over here, instead of saying notice returnable in 6 weeks, because if you say notice returnable after 6 weeks, sometimes we found that matters were coming back after 5 years.
Yes, my lord, it has happened.
So we list it on a particular day and say that the interim order will be up to a particular day. So we have control over it.
No, and
we know that the petitioner will also come back to us for extension of the order.
And no, thereafter also sometimes it does not reach, my lord. On that particular day, it is on board. It does not reach. And the respondent seeks an adjournment, my lord. Circulates a letter and gets an adjournment after. Lord, but there are various circumstances, my lord.
All right. Thank you, Mr.
I'm extremely grateful to your lordship.
Right. We've got your note here.
501.1, my lord. Lord, I respectfully adopt, my lord, all that my learned seniors before me have said, my lord. The 1 or 2 things, my lord, that I may want to add. The genesis of my matter, my lord, is a classic example of the problems with, my lord, Asian resurfacing.
Right.
This is a criminal trial. These are advocates, my lord, who appear for an accused. They have been roped in, my lord, as conspirators with the accused, my lord.
Yes.
I secured a stay, my lord, in the High Court in 2014. Matter doesn't come up, my lord. The stay now stands vacated by the orders, my lord, that I have impugned before your lordships. only on the ground, not on the ground that I'm seeking an adjournment, not on the ground of anything else, not on the ground, my lord, that the stay deserves to be vacated for A, B, or C
Only on the
reasons.
ground of Asian resurfacing.
Only on the ground of Asian resurfacing.
Yes.
So, my lord, most of it has already been said, my lord. I'll just take a couple of minutes, my lord. May I only point out, ultimately, my lord, judicial discretion, my lord, is the essence of the adjudicatory process. What Asian resurfacing has done, in effect, is completely, my lord, taken away that discretion that the Honorable High Court, my lord, has exercised or is to exercise in respect of giving interim orders. It's
Yes.
not that an interim order is not given without application of might, my lord. Your lordships have already observed, and others before me have already argued, my lord, that the aspect of application of mind is taken away. What it also does, my lord, is dilutes the power of the High Court under section 482 as well as, my lord, 226.
Yes.
Finally, my lord, I'll just put it all in the note, my lord. I don't want to waste your lordship's time. The basis for Asian resurfacing, my lord, if your lordship see paragraph 36 and 37, the basis for Asian resurfacing is a judgment called Imtiaz, my lord,
Yes.
where your lordships, my lord, have discussed the delays in trials, etc. There is really no reasoning, my lord, why Asian resurfacing paragraph 36 and 37. Well, the intent, my lord, is very good. The intent, of course, my lord, is to avoid delays in trials and promote speedy trials. There can be no doubt about it, my lord. But there is no specific, as Mr. Dwivedi has already argued, never arose, my lord. But I'd like to end, my lord, with what Justice Holmes said, my lord. Life of the law is, my lord, experience, not logic. Asian resurfacing is probably logic, my lord. Your lordships, my lord, 5 years of experience, my lord. Grateful.
Thank you. Thank you, Mr. Pai.
Lord, Mr. Mehrotra is appearing online, my lord, if I'm permitted to address.
Anything else, Mr. Mehrotra, apart from what has been said? Yeah, please unmute yourself. You're not audible. Mr. Mehrotra, you're not audible. You'll have to... You're still muted, actually, at your end. Yes, now you're unmuted. All right, you just set your house in order. We'll hear Mr. Naski in the meantime.
I appear in Mr. Pai's matter for the state of Andhra Pradesh, and I completely support, my lord, Mr. Pai in that. Not just one addition, my lord. My lord, what your lordships have done, my lord, in the judgment is that you have also imposed fetters, my lord, on the very exercise of jurisdiction. And I would only draw your lordship's attention, my lord, to a constitution bench judgment of 1964. My lord, I have passed on the judgment. It is AIR 1964 SC 1573. Your Lordship Gajendra Gadkar speaking.
What is the name of the judgment?
Your Lord, the name of the judgment is B. Rajgopala Naidu versus State Transport Appellate Tribunal. Not here.
What is the para? What para would you be referring to?
Milord, para 19 would be relevant, no? I'm only drawing a parallel. Where, my lord,
We now request all members of the bar to start citing SCR. Because SCR is now up to date up to the last few days.
There is an SCR citation also, may I?
And with neutral citations as well.
We would certainly do that.
And now that the Allahabad High Court Bar Association is before us, ESCR has now 30,000 judgments in Hindi. All judgments of the Supreme Court since independence are being translated into Hindi. It's in a searchable format. So exactly the facility which you have available on the English SCR, you have in the Hindi SCR. So please spread the word and...
Lord, what was sought, my lord, to be done in this judgment is that by what...
And this is being now extended to other Indian languages, brother. Oak is very actively monitoring that.
My lord. Lord, what was sought to be done, my lord, in this judgment is by way of a statute, my lord. A fetter was sought to be imposed on how the quasi-judicial authority would exercise jurisdiction. My lord. Lord, that your lordship said is not permissible. Would your lordship have para 19 minutes? May I have, sorry.
Is there, helmet is there.
How does it begin?
Lord, may I just pass on the hard copy?
No, we have it here right in
Lord,
front
it
of us.
says-
You have it on your screen as well. All the lawyers will have it on your
Lord,
screen. There
in
it is.
reaching the conclusion.
Yes, we got it.
That's the one. Lord. In reaching the conclusion, we have been influenced by certain other considerations which are both relevant and material. Now the relevant part. In interpreting section 43A, we think it would be legitimate to assume that the legislature intended to respect the basic and elementary postulate of rule of law, that is, that in exercising their authority and in discharging quasi-judicial function, tribunals constituted under the Act must be left absolutely free to deal with the matter according to their best judgment. It is of the essence of fair and objective administration of law that decision of the judge or the tribunal must be absolutely unfettered by the extraneous guidance by the executive or administrative wing of the state. If the exercise of the discretion conferred on the quasi-judicial tribunal is controlled by such direction that forges fetters on the exercise of quasi-judicial authority, and the presence of such fetters would make the exercise of such authority completely inconsistent with the well-accepted notion of judicial process. So,
Yes, all right. Thank you.
Just drawing a parallel.
Anything else?
Lord Mr. Mehrotra, I don't know if he's able to come.
Mr. Mehrotra? Is someone appearing in person?
No, Your Lordship will then allow me to place them.
Yes, Mr. Mehrotra.
There seems to be some.
The problem is persists, Mr. Mehrotra. If you filed your written submission, we'll read them.
Yes, filed.
You have filed your written submission, we'll read those.
Yes, filed.
All right. Anybody else? Are we all done?
Lord, I just wanted to add, my Lord, one judgment, my Lord, Mittu versus Punjab, Your Lordship will recall, my Lord, taking away of judicial discretion.
That's right. On the death penalty.
Yes, definitely. Grateful.
Very well done.